I'm going to take the step. I had done this yesterday, and some of you are not on here. Some of you that are on here were not on here yesterday. So let me, well, never mind. I was going to tell you that, I was going to warn you that we were trying to follow the Supreme Court rule, and we were live streaming. But it is telling me that live streaming won't work.
Mine says we're live on YouTube.
I know. I'm trying to figure out why I got the message that says it's not working, and in the corner of my screen it says it's working. So I am going to assume that it's working, and just as a matter of fair warning to everybody that this appears to be streaming. Mr. Whitlow is with us. Let me get down here to your file, buddy. All right. I am thinking that we did an arraignment on Mr. Whitlow's case a couple of weeks ago. He indicated that he was going to be represented by Mr. Soam. I don't believe Mr. Soam had been aware that Mr. Whitlow had gotten arrested, so he wasn't on that call. Mr. Soam, he was arraigned. If you would feel comfortable me doing that again, I would, but I explained his indictment to him. The Commonwealth has filed a motion to revoke bond and wants to have a hearing on that motion. I do not believe that we intended to have that hearing today, although if we did, I'd be happy to do it. But I'm not sure you had been served with it, because I don't think anybody knew at the time that you were representing him when the motion was filed.
And I
Your
believe
Honor,
go ahead.
I'm sorry, I was just going to say Mr. Soam and I had discussed the bond issue, and I think Mr. Whitlow's been in since January 2nd. Basis of the bond revocation was a new arrest in Metcalfe County, a misdemeanor that he's not pled guilty to. It is a pretrial set, I believe, sometime in February.
Okay.
At this point, I wouldn't necessarily be opposed to him getting back out on a bond that would involve an ankle monitor and monitoring. The other issue that Mr. Soam and I had talked about is that in Cumberland Circuit Court, he is charged with theft. And the theft of the property is the same property that's involved in the Metcalfe County case. I've talked with Jesse Stockton about that, seeing as I think it's a duplicate case. I think Mr. Stockton is of the opinion that he can proceed with his theft and I can proceed with the receiving of the same property, but he said he was going to look at it. And I think he has a pretrial conference in Cumberland Circuit Court on this Thursday. So I'm not necessarily opposed to him getting out as long as he's on an ankle bracelet and is monitored. And I would ask that maybe we put this out to the second date in February, and hopefully by that time we may know a little bit more how Cumberland County and Metcalfe County are going to work on these cases.
Okay.
That sounds great to the defendant, Your Honor.
All right. Mr. Soam, has he secured release out of Cumberland County so that if I change the bond, is it going to be released, or does that have to go back to Judge Williams first?
No, Your Honor, he's been released. He was arrested only on the new charge.
All right. Fair enough. Okay. Mr. Whitlow, the way that we'll do this is we'll put you off. It's going to be roughly a month. That day is the 23rd of February at 9 a.m. Now, of course, Ms. Gardner, the complicating factor there, I suppose, is that we won't be meeting in person at that point in time. So there's a distinct possibility that we will be in March, but I still don't know, that's a fluid situation, as they say. So we kind of have to play it by ear, but it might be better to put this on for that first rule day in March, because I know that we won't be meeting in person. I mean, the alternative would be he could go to Mr. Soames' office or log in some other way, and participate remotely from some other location, but we won't be doing it in the courtroom. Does that make sense?
I'm fine with whatever Mr. Soam and his client want to do.
Whichever you like, Your Honor.
All right. Well, I tell you what, let's do the March 9th instead. Because there is a chance that we'll be back in person. But, Mr. Whitlow, what that means is that you're going to have to stay in contact with your attorney, which I don't think is too much to ask. And then, hopefully he'll be able to keep his finger on the pulse and know whether or not you're going to be in court or remote. Okay?
Thank you, Your Honor.
All right. We're going to, normally when we do our ankle monitors, we do that through the U-turn monitoring over here, which is in Glasgow. I don't know if Mr. Soam has a different idea. I'm not beholden to them. Don't have any financial stake, so I don't care where he gets his ankle monitor, but I want him to get an ankle monitor at some reputable place. I know that most counties have that available now. So if you all use something different over in that area, that's fine. But it probably will need to be the U-turn, just because generally the way we do it is have them come hook you up like when you leave the jail.
We have no preference, Your Honor.
Yeah. What we'll do, Mr. Whitlow, is notify the U-turn office that somebody from your contingent of folks might be calling them and telling them that you're going to get an ankle monitor, and they'll make arrangements with them and they'll come up and put it on you. Okay.
Okay. Thank you, Your Honor.
All right. Fair enough. And then we'll take care of that from now until at least from now until March the 9th. Theoretically, something could happen before then, and you all could enter an agreed order of some kind. I mean, if the case is going to be dismissed, it may be dismissed in one county and not the other one. Who knows? Okay. So, but anyway, when you get out, you need to contact your attorney and be sure that you all are singing off the same page of the hymn book. Okay.
Okay. Thank you.
Thank you.
Thank you, Your Honor. That's all I had.
All right. Take care. Good to see you.
Good to see you, Judge. If you undo me something.
All right. Let's see. Mr. Pack, we can call that case next. This is Brandon Nelson. Mr. Nelson got arrested on the basis of a warrant. The warrant was issued because probation and parole filed a violation report regarding Mr. Nelson, and that violation report said that the last time we were in court, Mr. Nelson had been ordered to get an assessment and comply with treatment. Since that time, he has had now this is what the allegations are, that he's had a dirty drug screen, which was dirty despite the fact that he attempted to alter the results of the drug screen by adulterating the sample, and that he has failed to attend his life skills, which were part of his probation, because that's what his assessment required him to do. The probation report, violation report, did not ask me flat out for a revocation, but it asked me to lodge him, and wanted to discuss what the options were going forward, from whether he was going to straighten up and fly right or not, I guess is what they were shooting for. So I issued the warrant. He got arrested. Here we are. I don't know. The Commonwealth at this time, this has been a fairly short turnaround. I don't see a motion to revoke. The Commonwealth may not be seeking revocation. They may be just asking the same thing that the probation officer asked.
Judge,
Could ask
that
me to
may-
revoke him as well.
I think we probably will file a motion. There might have been a little mess up. Officer Bragg, I think, was supervising him and sent the violation report to Darlene. Typically Micah is the one who handles the one for Metcalf. So actually I just got the email from Darlene today with the violation report. So I haven't really had a chance to review it, but I would say that it is something that I would be seeking to file a motion on.
Yeah, like I say, it's all this turned around. I mean, I think I issued the warrant on Thursday afternoon, so it's not like there's been a lot of time go by for everybody to discuss what they wanted to do. But Mr. Pack, let's be clear about something, just so the DPA understands. You're here as a member of the public.
Well, that's what I was going to, I've got to my left here, Your Honor, or right, depending on your perspective, I've got the father of Brandon Nelson. He asked that I appear today. And I think it would be wise for me to go ahead and enter an appearance on behalf of Mr. Nelson if he
Okay.
now Brandon has to agree to that. Brandon, do you want me to do that for you?
Yes, sir, please.
All right, then you can relieve, unless Mr. Barry's going to cry too many tears, which I doubt he will. I suspect he's got enough to do.
Well, I don't think they'll begrudge you this one time.
You know, I'll be happy to go ahead and get an entry of appearance entered and filed today. And then,
Okay.
And then if you want to set it for another hearing and give Ms. Gardner an opportunity to file her whatever motion she deems appropriate.
Yeah, I would think, of course, that this is something that would, off the record discussion would probably be fruitful. That an off the record discussion that did not involve me.
Yes.
But in any event, we'll set it for our next available hearing date, which is February 9th, and the second Tuesday of the month. And you know, I'll leave it to you and Miss Gardner to figure out whether or not you're going to talk about it before then. It's not, no skin off my nose either way.
Judge, how can I get that report? I know it's not on CourtNet, the probation parole report. Is that something I'm entitled to?
I'll attach it to my motion.
Yeah,
That'd be-
when she files the motion, it'll have it attached. It's
Okay.
a court record, but of course it's hard to get into a clerk's office.
Yeah.
So, yeah. But she'll certify service on you and she'll attach that to the motion.
All right, that'd be great, Your Honor.
All right, so moving forward then, we'll set this for the 9th day of February at 9:00 a.m. unless I hear something different. Okay,
All right, thank you, Your Honor.
thank you.
Judge, if I could jump in for a second. We had a revocation hearing for Joshua Posey, and I've got Hunter Carroll on standby to testify.
Okay. You all ready for that one?
Yes, sir.
All right, let's see. There we go. Can you raise your right hand for me? Do you swear or affirm that your testimony will be the truth, the whole truth, nothing but the truth? So help you God.
Yes,
All right. Go ahead, Mike.
Can you state your name for the record?
Officer Hunter Carroll.
And you work for Glasgow Police Department?
Yes, sir.
And on September 15th of 2020, did you come into contact with a Joshua Posey?
Yes, sir, I did.
And you arrested him that day?
Yes, sir.
Can you tell the court what led to his arrest?
Yes, sir. Officer Manier conducted a traffic stop on Park Avenue of the homeowner of 102 Travis Court. A passenger in the vehicle was arrested for possession of methamphetamine that she had on her person. The operator had stated that Posey was at the building beside her house on Travis Court and possibly had drugs on him as well. The subject arrested out of the vehicle was Posey's girlfriend. I then traveled to 102 Travis to make contact with the subject. Upon my arrival, I made contact with Teddy Wise on Travis Court, who was standing outside in the middle of the street. Upon my arrival, I observed a white male in a dark colored shirt take off running inside of a garage outside on Travis Court. After speaking with Weiss, I advised him to tell the subject to step out of the building and to come out and talk to me. After the subject exit, he matched the description of the subject that took off running inside the building, and he was identified as Joshua Posey. He allowed me to conduct a search of his person on consent. I asked Posey why he took off running, and he stated that he never did. I asked if I could at least look in the building inside of the area he was in. Upon looking in the area he ran into, inside of a 32-ounce fountain drink of Mountain Dew, I located a needle with suspected methamphetamine inside. Posey stated that it was not his and that he does not use needles, although he did have Mountain Dew inside of the building. Based upon the information, Posey was taken into custody and lodged in the jail.
Pass the witness, Judge.
All right. Mr. Austin?
Oh, I thought I was, sorry.
There you go.
So you asked Mr. Posey for consent to search the building?
Yeah, in the immediate area that he had ran into. Yes, sir.
And he gave that to you?
Yes, sir.
All right. He said that the cup that had the needle in it wasn't his, but you said he had Mountain Dew in there as well. I mean,
Correct. He didn't specify what he had. He didn't say if he had a can or a fountain drink. He just specified that he had Mountain Dew inside of the cup, and that was the only Mountain Dew I found inside.
okay. Were there any other drinks inside the building?
I'm not sure. I can't remember. I do remember that being the only Mountain Dew inside of the building.
No further questions, Your Honor.
All right. Redirect, if any.
I don't have anything else, Judge.
Very good. Mr. Richardson, if that's all your witness is for, he may be excused.
Yes,
Mr. Austin, do you have any proof?
I don't have any proof. I would just,
Okay.
I'd just like to argue not to
Yeah,
revoke.
go ahead.
From the testimony of the officer, I can definitely see how his suspicions would be raised, but it doesn't sound like he was the only person that had access to that area. Who knows how long that had been there. I would just like to argue that Mr. Posey's bond not be revoked.
Understood. Mr. Richardson.
Well, I think he's violated his bond conditions, Judge. He's, participating in, using drugs. I mean, I think it's pretty apparent that's what he was doing at the time. And on top of that, he tried to run from police as well, which shows he's definitely a flight risk. So I think there's enough there. I mean, it was in his possession. There was enough there to have his bond revoked.
Well, listen, here's the situation that we are up against in Mr. Posey's cases. These cases are working on 2 years old. And basically all I know of that we've really accomplished throughout the course of this year and a half or 2 years is bond revocation hearings, of which we have had, I don't know how many hearings we've had, but I mean, there's been at least 3 different times that I've had to issue a warrant for him and he's had to get arrested, and then I've reinstated a bond and let him back out. He's been arrested on multiple occasions in other counties, either for probation violations or whatever the case may be. I can't really recall right now, but all along since March, when I released him due to the incipient pandemic, I think he's been arrested 2 more times just in these cases. And quite frankly, what we need to do is get to a point where things are settled down enough for him and his attorney to talk and to discuss things with the Commonwealth attorney and see whether there's any path to resolution on this case. And the only way that I can really see that happening to keep him from getting arrested and going all over the place is to revoke bond, which I do think is warranted because there are multiple violations of bond here. Mr. Posey has a pretrial conference already scheduled for February the 23rd at 9 o'clock. So that'll give us 4 weeks to discuss this thing and see if we can come up with something. He can meet with his attorney. If there's discovery that needs to go, that they need to go over, they can get the chance to do that. Mr. Richardson can make an offer if he hadn't already. Mr. Austin can make a counter offer if he hadn't already, and we'll see whether there's anything that we can accomplish. But, you know, we're not getting anywhere with everything else that's going on. I mean, you know, he just keeps getting arrested and getting out and getting arrested and getting out. And I mean, at some point, you know, I need to realize that that ain't working.
Sure, I'll keep in touch with my attorney if you let me out. And
Mr. Posey, I've already decided what we're doing, okay?
All right.
I'm going to grant the motion, not set, but reinforce the idea that we have a pretrial conference. It's already set for February 23rd, 2021. And we will see you then.
Okay.
Thank you.
Judge, are you okay if I go ahead and sign off?
Sure.
All right, thank you, sir.
All right, let's see. Jonathan Greer. Good morning, Mr. Greer. You're here today because there was a pretrial conference scheduled back in July 14th of 2020. And I believe everybody was there but you. And so I issued a warrant for failure to appear on that basis. I don't know. I think at one point, Mr. Bell might have been involved in this case, and I don't know if he has any idea that there's been a new arrest because he's not on here. But you know, I feel like probably we're going to need to schedule it for a hearing, and the Commonwealth can notify him if that's what needs to be done. So here's what we will do. Which one of you is handling this on the Commonwealth side?
My case, Judge.
All right. All right. And in the past, whenever there's been communication, has it been with Mr. Bell?
From what I remember, yes, we didn't have, I guess, that much before, you know, he didn't show up to court, but I think we got as far as sending discovery and an offer, I believe.
Are you Mr. Greer expecting that Mr. Bell has been employed to represent you, or did he just appear with you?
I'll tell you what, Your Honor,
I don't remember.
It's been going on so long that I just about to do anything to get it going. You know, if Mr. Bell's in it, he's in it. If he's not, he's not. I didn't talk to anybody, and I'm wore out with this one. I mean, I wouldn't be opposed to doing anything right now.
Well, would you like me to just appoint you an attorney so that you know who your attorney is going to be and who can come talk to you? Or do you want to wait till February 9th and see if Mr. Bell shows up?
Well, I tell you what, I just say you put me on an ankle monitor or something and we get Bell back on it. But whichever one you want.
Well, you don't ask for much. Do you want me to appoint you an attorney or no?
Yeah, might as well. Yeah.
All right. That can be done. Sounds like, y'all got some things you can talk about. We're gonna put this on for February the 9th at 9 o'clock for a hearing. And I'm appointing counsel, so presumably Mr. Austin and Mr. Richardson can discuss matters and so on between now and then. But Mr. Greer, I don't know what'll happen on the 9th of February. I may put you on ankle monitor, who knows? I'm not gonna do it today though, okay? All right, thank you. Scott Mars.
I've talked to Mr. Mars. We have an offer on his 2 Metcalf and 1 Barron County case to resolve all of them. He has indicated a willingness to accept that offer, but he would need a month or at least a couple weeks out so he could get his affairs in order. Otherwise, he's going to lose everything he owns. I mean, the offer is for 13 years, so, you know, by the time he gets out, you know, everything's going to be gone if he doesn't do something about it before he goes in.
Your Honor, the Commonwealth understands Mr. Mars' sentiment on that, but it would be opposed to it. I think that there was issue trying to serve Mr. Mars with a warrant, if I remember correctly, and the Commonwealth is concerned about a flight risk if he's let out.
I mean, he's been locked up for a long time without, you know, I'm not sure if we ever, when the last time he addressed bond was in this case, to be honest.
Well, just about every time I see him, he asks me, which I don't blame him. I mean, you know, I understand. Listen, Scott, here's the deal. And Mr. Gardner's kind of put it pretty succinctly. I mean, everybody would understand why, you know, if you're getting ready to take a deal that involves a little bit of time in custody, a lot of time in custody, that you might want to get out and kind of dot some I's and cross some T's and that kind of thing. I haven't had very good luck with that in the past when I've tried that with people. I'm not saying that every single person that I have done that for has done something wrong, you know, run off or not shown back up. But I can say with a pretty high degree of certainty that you can count on one hand how many people don't screw up when I let them out, and they do that. And most of the time they just don't show back up till we go get them. And then when that happens, their deal's off and they're, you know, everything else. My tendency, and Mr. Austin, I don't think we've never had one of these come up since he's been handling court over there. But my tendency has been that I'm more likely to, which I haven't had a whole lot more luck either doing it the other way, but it is, you know, my options are greater. I'm more likely if somebody enters a plea and then I can let them remain out until they get sentenced, I'm more likely to do that because at that point they've got a whole lot more skin in the game because their sentence recommendation goes out the window if they don't show back up for their final sentencing, and they can get the maximum sentence for the charge. So that tends to, at least in theory, work better. I don't have any, I mean, anybody can tell me anything about we've got a deal worked out and we're going to do it. And, but I mean, that's not binding on anybody until they enter their plea. So, you know, I don't, anybody can tell me anything and then get out and change their mind, you know.
I would do that. I'd enter the plea. I told Robert I would do it, that I would enter the plea beforehand and do that. That's how we spoke about that.
If I would say that you would have to understand, and I think you do because you've been around the block a few times, that I don't believe that's part of any plea offer from the Commonwealth. I don't think they're offering to, you know, as part of the plea, if you accept this, we'll agree to let you out pending.
Oh, he just said it might come up.
But it would be something that you would just have to, and I mean, I'm not promising you that I would do it either, but I'm telling you that I'd be more likely to do that than the other.
All right.
And just so we're clear, I mean, the Commonwealth will oppose that.
I understand. I mean, that's what I'm telling him, you know.
Yeah, I mean, right.
I don't want him to think that anybody lied to him because you know, you're not going to lie to him and I'm not going to lie to him. But all I can tell you, Scott, is that, you know, to me, a person who is got some brains about them like you do and is prone to make calculations like you are, and that's not an insult, that's a compliment. But I think, you know, your calculations would lead you towards, you know, putting a lot more leverage on you behavior wise if you entered your plea and then you were out for a bit before you came back for your sentencing. Again, I've tried that before. It hadn't worked real well, but you ultimately get the people back anyway, and then they end up going to jail for a whole lot longer than they would have gone for. So, I mean, you know, they reap what they sow, and you know, that's the way of the world. So, you know, I'm a lot more likely to take that risk than I am to take any other risk. Does that make sense?
Yeah. Yes, it does.
If you all want, I can put you on the next rule day that we've got, which is February the 9th. And if that's a paperwork deal that you all need to get done, and then we'll have that, you know, we'll have that conversation. Is that what you want to do?
Yes, sir.
All right. Let me also, and this, well, we'll talk about that later. So we'll pass to February 9th, 9 a.m. And just to be sure, you know, I feel like I need to ask this each time, but Scott, you agree that your Barron County case can be done on this Metcalf docket with the rest of the cases? Is that okay with you? All right. That's what we'll do. Thank you.
Thank you.
Timothy Pittman.
Your Honor, I was not aware Mr. Pittman was on the docket until this morning.
Okay. Well, that makes sense because I think he just got arrested Sunday.
Your Honor, this is my case. Micah has prepared a motion to revoke his bond. It's actually, I'm in the process of trying to get it e-filed right now. So there will be a motion here shortly from the Commonwealth.
Okay. We can put that on the February 9th as well. Since you're going to have that done, that'll be plenty of notice.
May I ask why? I've been doing everything that I was supposed to be doing. I went to the treatment program. I graduated it. Haven't had no new charges.
Because you were on random drug screens and they called you twice and you didn't come to either test.
I was never told to go to the random drug screens. I was nobody ever told me to go do that. If I would have known, I would have went to U-turn and done that.
You've been on random drug screens since December of 2019.
Well, sir, I asked you the last time I talked to you, which was in here, if I had to go to U-turn, and you didn't say anything about it. You just said go to the 30-day treatment program, which was Lake Cumberland Recovery. And I just now graduated that. So If I would have known, Your Honor, I definitely would have went because I've been doing everything else that I was supposed to be doing. I don't see why I wouldn't have went to that as well.
Well, listen, you've been on the same bond since your district court case, which involved you going to U-turn. You know, then you got arrested. I told you that I would let you go to treatment. I would reinstate your bond, which that I reinstated your bond. It had the same conditions on it it always had with the.
I didn't know that.
Go to treatment.
I didn't know that, Your Honor. I don't know what I was thinking, but when you said you reinstate my bond and then you make, I thought it was new conditions. I didn't know it followed the same ones as well. If I would have known, Your Honor, I definitely would have went and got them drug screens. That's why I've been sitting confused at why I got arrested, because I was doing everything that I was supposed to be doing. And I guess I didn't go do the drug screens, but I didn't know I had to still do those.
You know, listen, let me make the same observation that I've made before, which is, you know, again, this is a case that the only charge of any significance in that you have is possession of a controlled substance.
Yes, sir.
You've gone to rehab.
Yes, sir.
I don't have any reason to believe that you didn't complete that because there, you know, nobody sent me anything. I got a letter from them when you went, and I didn't get any other letter from them saying that you left without permission or anything. So I believe that you completed that, honestly, and I think you may have proof of that somewhere, but I never got it. But that doesn't mean it didn't happen.
Yes, sir.
I'm not sure why this would be the sort of case that could not be resolved somehow, because I know what the Commonwealth generally is going to ask for, and I know what the law generally requires for this kind of case, and they're not going to ask for something that they can't ask for as a plea. So this is what I'm going to do. We're going to set your hearing for February the 9th. However, I'm going to ask your attorney in the Commonwealth to, if there's a plea offer out there, I'm going to ask your attorney to talk with you about it as soon as he can and reply to it. If there's not, I'm going to ask the Commonwealth to get you one as soon as it can get around to it, and get your attorney down there to talk to you about it, or call you, or however they're doing it these days. And, you know, if y'all work it out before February the 9th and it is something that can be done, we'll do it before February the 9th. Okay?
Yes, sir.
But I mean, this is you got arrested over a year ago, and, you know, these cases are really pretty easy to work out as long as everybody's doing what they're supposed to do. And, you know, it's 14, 15 months later and we're still piddling around with it. And I mean, I'm going to try to see if there's a way to get it worked out in the normal, ordinary course of business, right? I understand that you might have thought that you weren't supposed to go get those tests, but I mean, when you're out on bond and somebody says, I'm reinstating your bond, that means they're giving you the same bond you've been out on.
I didn't realize that.
Well, I understand that, but, you know, be that as it may, we're here where we are. And, you know, I really think this thing can probably get straightened out fairly easily. If it doesn't, I'm going to see you on February the 9th, but if it does, then I may see you before then.
All right. Will I still get to get out today so I can continue the job that I've just required?
No, I'm not going to, I mean, if we don't get anything straightened out till February the 9th, you'll be in there till February 9th. If y'all get it straightened out before then you might get out before then.
Robert, my notes indicate that I've sent you an offer in this case. If you'll double check on that.
I'll have to go to the office because I'm not seeing it on the Justware.
Okay, well, my notes indicate that I emailed you the offer. So
You mailed it to me? Okay, I can check that then. Yeah.
Is there any way I can hear that offer? Maybe we can come to an agreement today.
Well, I don't think that's something that needs to be discussed on the record, because that violates all of your attorney-client privilege and your right to remain silent if you all sit up here and negotiate all this in front of everybody. Just let him get in touch with you and talk to you about it, okay?
Okay.
All right.
Yeah, I have the offer.
Seth Rigsby.
That's my case, Judge.
All right. Hello, Seth.
How you doing?
I'm doing all right. How are you doing?
Decent, decent.
Judge Reese had sent me an offer on this case a while back. Went over it with Jerry and made a counter offer on it this morning. And Reese had just sent me back a reply to that. I need some time to talk to Seth about it. He's serving right now a 10-year sentence, so he's probably going to be in there a little while, one way or the other. So if we could set this for the next circuit court date, then we should have it done one way or the other. We'll have an.
Do you want to do the 9th or the 23rd?
I would say the 9th, Judge.
Okay. 2/9, February 9, 9 o'clock.
Okay. I think that's all I have on the docket today, Judge. I was going to exit out of here unless there's something you need me to.
Nope, you're good to go. I think
Okay.
that's the docket anyway.
Okay. See you at 1:30.
See ya. Everybody else stay on here for a minute. I'm gonna let the jail out though. Bonnie, that is everybody, isn't it?
Yeah, Judge, that's all I've got.
All right, I'll see you in a little while.
All right, see you, Judge.